So everybody's favorite topic, how do people screw up? Well, it's kind of like medicine, right? You want to learn about this, so you want to learn the best lessons are other people's screw ups that you learn from, right? So, not that I'm using any names or anything like that, but I do want to give you guys some of the common things that I've dealt with in my 25 years working with not just startups, but businesses of all different sizes. But most of the clients I work with are entrepreneur-led. Very few public companies. I'm a corporate transactional business and technology lawyer, and so most of my clients I'm dealing with the owner or somebody in the C-suite of a venture-backed fund, privately held companies for the most part. And so, but I'm going to focus on more of the startup early stage ventures because this is where I see a lot of these mistakes. But there will be some that maybe a more mature business still hasn't quite addressed, but I see it more commonly in the startup. First and foremost is no legal budget. Okay, that's something that nobody wants to talk about because you don't make money off legal, right? Only I do. You guys don't. You see law as sort of a necessary evil or just necessary, one or the other. But the truth is, it is very important, particularly to a startup business, particularly to a technology-based startup where you don't have cans of soup in a warehouse. All you have is knowledge, right? Whether it's software, source code, secret algorithms, or so forth. So a legal budget is part of your business plan. Okay. And having a good relationship with a legal counsel, the right kind of legal counsel, is a good way to ensure that your great, mousetrap that you've invented stays yours, and then you can do something with it. So I like to refer to the law as a suit of armor. Okay, the way I look at it, it can be a sword or a shield, but I like to think of it, I'm dressing up the knight, right? So everybody's safe if they stay in their cave. You never try anything, you never do anything. Hopefully you're safe. I guess maybe at home there's some things that can still happen to you, but not as many things that can happen to you in the real world. And if businesses don't go out in the real world, then they're fairly safe. But if you go out butt naked, well, a lot of bad things can happen to you. So you need something to protect you from the slings and arrows of things, of people stealing your IP, your ideas, slip and fall in your parking lot, all those types of things. So how do we do that? Well, we wrap you in a shield of armor so you can go out there and do what you need to do and still be safe. So that's the way I want you to think about legal protection. So obviously, if you were a knight and you were fighting battles, you would budget for a shield of armor. So that's what you need to put into your budget. The second one up here at the top, we'll go across the top and then go down, is the wrong lawyer. Okay, so what is the wrong lawyer?
All lawyers are not the same?
No, we're not, believe it or not, we're not all the same. And picking a lawyer can be like picking a CPA or a doctor or an architect. There's a little bit of a vibe there, but there is an art to this. Okay, there's an art and a science to picking the right lawyer. First and foremost is the lawyer, if you want to deal with one lawyer, most people don't want to do too many, you want to deal with a lawyer that can handle a lot of what you need. Somebody that's familiar with the type of business you're in, but a lot of folks say, well, I'm coming up with a new invention, so all I need is a patent lawyer. That's great, you probably do need a patent lawyer, but chances are you're going to be a corporation or an LLC or some other type of entity. You're going to need to raise money, you're going to have contracts. Trust me, patent lawyers are not good at that. They're really good at patent law. So when it comes down to understanding the right lawyer or the right lawyers, you need to appreciate that there are different types of lawyers. And also, understand a little bit about law firm economics. Everybody thinks, all right, well, I've got $1 billion idea, so I should go get a lawyer for $1 billion company. Probably not a good idea with that first thing, that legal budget. It's not a good resource. Not all lawyers charge the same hourly rate. And I say shop around. But just because a lawyer is less expensive doesn't mean they're not as good. For instance, my firm is a boutique technology law firm. We're all former big firm lawyers. So we were all trained in the big firm stuff. We still charge quite as much as we would charge now because we don't want to work in that environment anymore. We don't work with Fortune 500, we work with smaller companies. So appreciate that there are different types of lawyers and different specialties of lawyers and understand which one you know. When in doubt, find a business lawyer. Right? Start with there and then go from there. Doesn't mean that you can't, but if you only have one good lawyer you know, if you have a patent lawyer that's a friend of yours, went to college with, and they're really trustworthy, start there. Okay, and I'll finish with some examples of how to find a lawyer, some tricks, some tips to find a good one, and then also how to work with a lawyer. This is something that after 25 years of law, I would love it if all my clients understood this. It would make them happier, make me happier. So I'm going to tell you guys, in case you haven't had to work with lawyers a lot, this is some ways to make sure that you don't have problems with your legal counsel. Getting into, especially the early stage startup, overly complicated entity structures. Okay, so-and-so said if I want to start a startup, I've got to be a Delaware C Corp with preferred shares and all this stuff. Maybe, maybe not. The question is, when are you going to raise that money? Where's that money coming from? Let the money pay for that. Okay, be as simple as you can for as long as you can. That's my general principle. If starting out as an LLC is the way to go, Start out as an LLC. If your money eventually comes from family offices, they might prefer that you're an LLC for pass-through tax purposes. There are a number of considerations of entity choice and where you form the entity. So when you form an entity in the United States, it's not a U.S. entity. Okay, one thing to appreciate, particularly those of you who are not from the United States, you don't form a USA corporation. You form a Texas corporation, or a Delaware corporation, or a Wyoming LLC. So there are multiple decisions that need to be made, and that's something that you start with a list of goals. This is what we're trying to achieve, and I would say plan for a couple of years. The first couple of years, what do you need? Where's the money going to come from? If you've identified an investor and they want convertible debt or whatever, or they want preferred dividends, well, that's fine. Go ahead and set it up. But if you don't know where that money's coming from, keep it simple. You can always convert. You can always say, hey, we were a Texas LLC, but our investor is going to bring in $5 million. They want us to be a Delaware C Corp. There's a way to get there. Guess what? They'll pay for that. They'll be part of the investments. You get that in there. But don't overcomplicate it on the front end, because that's a good way to get yourself into serious trouble, because a lot of different types of entities have a lot of formalities, and if you don't follow them, you can lose the benefit that we all want, which is limited liability protection. And so by not following those formalities, that's a good way to get in trouble. Copying contracts from the internet. We've all done it. I do it. The difference is I don't want to build it. Okay? I've done this for 25 years. Okay? I often will plagiarize. Law is about plagiarism. That's all we do. Nobody cares what Jim Chester says. They want to hear what 15 other lawyers and Supreme Court judges have said. So that's what law has always been about. Day one of law school. That's what we do. But for example, I've got a client that is in a social media space in the travel industry. And there are certain very specific nuances and challenges related to international travel and stuff that I don't understand. So I understand a lot of things that online licensing and websites need, but I don't understand that industry. So I'll ask my client, hey, give me the names of some companies that do what you do or something similar, and I'm going to look at their terms of use. And I'm going to see what I don't know about your industry based on what they're addressing in their terms of use. That gives me the ability to steal what they're doing. The problem is when you do it, that's like, if you're not a doctor, and there may be some doctors in here, from what I've heard, an appendectomy is not that big a deal. But if I were to do it, it would be a big deal, okay? So, but the right person with the right training can do this sort of thing. When you go in and you see a form, like, oh, this is an end user license agreement for software. I'll just take this from Rocket Lawyer or from whatever. That's great, and it may be okay, but just because you fill in all the blanks, doesn't mean that it's the right agreement for you. Matter of fact, that could be the worst thing for you, because then you have a false sense of comfort and security, when in fact you had an opportunity to get it done right. That doesn't mean that all contracts on the internet are bad. That's not what I'm trying to say here. If you know what to look for, and if you've had experience with it, then fine. There's no problem with that. Unfortunately, if you were a lawyer, you probably wouldn't be doing this. You'd be practicing law. But I'm an entrepreneur as well, so I do take some forms on the internet. So I break my own rule, but I give myself permission to do it. This is a very common one. Inadequate founder agreements. And what I mean by that is agreements among the founders. You got 2 or 3 buddies that are maybe they're MBA students together as part of a project, or they're just friends, or maybe people that work together in one place, and they say, hey, you're the engineer, you're the software code writer, I'm the marketing person, Johnny over here can get the money, so let's all form this entity, and let's get this done. Well, they start off with all the best of intentions, and then Johnny gets a new job somewhere in New York. And Johnny, who now owns 1/3 of the company, decides he doesn't want to participate in the company anymore. But guess what? Johnny owns 1/3 of the company. How are we going to get rid of Johnny? Or can we get rid of Johnny? Or let's say Bill, who was writing all the software code, decides he doesn't want to be part of the company anymore. But you don't have any agreement governing who owns the code. Well, guess what? Bill owns the code. The way software works is whoever writes the software, writes the code, by default is the owner. Just because they're an owner of a company doesn't automatically transfer that ownership to the company. So making sure that that is done is part of the whole getting the founder agreements understood, right? So understanding the agreements among the founders, and the time to do that, by the way, is early stage when you have no money and everybody loves everybody. Because when you have money, or when people don't love each other anymore, that is not the time to try to get this resolved. It gets very expensive, and my partners down the hall from me that do litigation would love to meet you, because they get a lot of money when you do stuff like that.
So the time to do the prenup is when you're about to get married.
Exactly. Not when you're getting divorced. It's not going to work when you get divorced. And another one is giving away equity.
Everybody understood that one.
Yeah, oh yeah, for some reason here, we're going to be close to home. Another thing to consider that I see a lot of problem in early stage ventures, particularly cash-strapped ventures, that certainly, but I'm talking about sweat equity, giving equity in your company away for certain behaviors, certain deliverables that may or may not come. The most common one is you give up the equity day one, and they haven't done the stuff yet. Well, if I were to pay you for the entire year's salary that you're supposed to earn for my business, and it's January 2nd, I mean, how dedicated are you on January 3rd or on March 15th? Because you've already gotten everything you're going to get from me. So if you have other risks or other concerns or other things that are priority, they're going to move to the forefront and my work gets pushed down. You may never deliver those things you're supposed to because you've already been paid. So there's a right way to do this. Whether you were talking about advisors, or maybe you want a software developer, and instead of giving them cash because you don't have that much cash, you say, hey, I'll give you 10% of the company, or I'll give you so many shares of the company. Well, you can do that. There's nothing wrong with doing that. But what a lot of startups don't appreciate is, yes, they have no money now, but they will. And that equity, once it's gone, it stays gone. And you now have a business partner, whether you like them or not, and they're there forever. So it's famously, I think Jeff Bezos sold 10%, I think, of Amazon for like $1 million. Okay, what's 10% of Amazon worth right now? I bet he'd love to have that back. Now that he's hurt, don't feel bad for him. He's doing fine. But the truth is, maybe that was a good investment. I mean, if Amazon didn't have that money, it's not Amazon. And I'm not saying it's a bad idea. There's a right way to do it. When you're talking about giving away or granting someone stock for behavior, for future sales, for managing your company, for being an advisor, first and foremost, make sure there are very specific deliverables that they meet. Maybe you vest it over time. I prefer not giving away equity, but options. Because options do all that equity does, but there's a couple of other benefits. One is, when you grant the options, not generally a taxable event. It's not a taxable event until they exercise the options, okay, which may be 10 years from now, okay? So if I give an employee the option to buy 10,000 shares for $1, when those shares may be worth $100,000, at that moment, until they exercise it, the IRS doesn't tax them. But if I were to give them $100,000 worth of shares, guess what? The IRS is going to want to check for whatever their tax rate is times $100,000. Even though they didn't really get it. That company's a private company that isn't making money yet. One day it'll be worth a whole lot of money. But now they got to write a check to the IRS today. So options are a great way to do that. Plus, for people who may or may not deliver something, or who are particularly for advisors and they decide to disappear after a couple of years, if you only own options, those options, if they're not exercised, guess what they do? They disappear. They go away, just like that person did. But if you have an owner of equity and they disappear, now you got a stockholder you can never damn find. Okay? And you don't know if you're going to notice them correctly. There's always a chance that they're going to try to blow up some acquisition deal. If they decide your company's all of a sudden worth something. But if they have an option and they never exercise it, they're not an owner. They're not entitled to come to shareholder meetings. And you don't owe them any distributions, okay? Because they're not an owner yet. So they have to stroke a check, even if it's a very small check, they have to do something to become an owner, okay? Another big one is not securing intellectual property. I could talk to you, and I see a former student of mine in the back. He knows I can spend a lot of time talking about intellectual property and how to secure it. And I have this model called the ISOO model: identify, secure, use, and enforce. That is how you take care of intellectual property. The first step that people fail is identify.
Can you repeat that?
The ISOO? ISOO. Identify, secure, use, and enforce. ISUE.
Okay, thank you.
Sure. And so the first one is the one they almost always fail: identify. And you think, wait a minute, I'm a technology company. Of course I identify my intellectual property. I have software. That's my intellectual property. Okay, I agree. That is some of your intellectual property. What aspects of your software are not embodied in that code? What aspects of your database, your client contacts, your methods of doing things, your brand, those types of things that are outside of the actual code that are still intellectual capital. Intellectual property encompasses trademarks, copyrights, patents, and trade secrets. Okay? You need to make sure your inventory, your intellectual property inventory that you create, just like you create an inventory of your products, or computers, or your cars, your IP inventory has all your IP in it. The biggest problem I see with the ISOO failure is identification, because you can't secure it if you don't know what it is. You know, if you don't know where it is, if you don't consider it intellectual property. So first and foremost is understand what your IP is, then secure it. And there's two ways to do that. direct and indirect, okay? Directly securing your IP, always remember this, you're thinking about sitting directly across from somebody. When you're negotiating a contract, that person or people are going to sign a piece of paper, or they're going to click accept, one way or another. That's a contract. That is a direct relationship. I have contractual, we call it privity of contract in the law world. So when you have contracts and you have privity of contract, then you have the ability to say, well, this is an intellectual property term that you took my idea and did something with it. This is a contract breach, simple contract breach. You said you weren't going to do this, or you were going to do this, and you failed to deliver. That's a breach of contract. That's direct. The wonder about that, the wonderful thing about that is, I can define my intellectual property very broadly. I own the rights to the word water. Not against the rest of the world, but against you, because you agreed I do. You agreed you would use the word water in your brain. But I can only enforce it against who? People who sign the contract, or people who click agree. So I can define my intellectual property rights broadly, but I can only enforce them against a narrow group of people who sign the contract. Now, indirect is the reverse of that. The rights I have are granted to be by some statute, some law. Registration with the United States Patent and Trademark Office. Registration with the World Intellectual Property Organization or some other patent granting by the EU or so forth. So I can get these rights, only the ones they grant me. So I have to fit within their narrow little box. My trademark has to be a certain standard. My patentable device has to be novel, unique, and novel, unique, and non-obvious. Right? That's the standard. So it doesn't mean they don't care about valuable or anything like that. Novel, unique, and non-obvious. Okay, that's the definition. That's the standard. Either meets it or it doesn't. Now, that's the bad news, is that I don't get to define what my rights are, the statute does. The good news is, if I can get it, I can enforce it against anybody in that whole territory. So if I got a US patent, I can enforce it not only against people who I have contracts with, but anybody who's making, using, or selling a device that has my patented technology on it, okay? So that's why if you're truly protecting your IP, securing it, you identify it, and you're using both direct and indirect means to adequately secure it. And then the next step, of course, would be using it or licensing it and then enforcing it, because you need to do that. No, there's not a police force out there that's going to do that for you. If somebody's violating your IP, you can call a guy like me, actually one of my partners, to send them a nasty grant, okay? Tell them stop doing that or we're going to sue you until we own your company. And last but not least, we all think we're going to live forever. And we all think Johnny, Bill, and Sue are all going to be partners forever. But guess what? Things happen. Things change. A very common failure in a lot of companies, particularly service-based companies where the parties are providing a lot of services, but not only there, is a succession plan. And when I say succession, I'm talking bigger than just somebody dies. But what if just somebody doesn't want to be there anymore? You know, Johnny doesn't want to be in that business anymore. Johnny got a job, Johnny graduated from his MBA program, got the job of a lifetime in New York, and is moving up there and can't work on this thing anymore. It happened to one of my clients. And very similar, it was somebody I met through the MBA program that was working on a venture, and then he got a job overseas, and he can't be there anymore. So the question is now, does the company continue without him? And if so, well, he's the third owner of the company. Does he get to ride that coattail for the next, however far it goes? Or is there some adjustment there? Again, the time to talk about that is when there's no money and everybody loves everybody. That's the early stage, right? The honeymoon phase. Once there's some ones and multiple commas in an account, all bets are off. Because we can't think rationally anymore. We're thinking backwards from entitlement and stuff like that, and I'm not going to get into the psychology of that, but it is ugly. It gets ugly fast. All right. I promised you a couple of tips on finding a lawyer and working with lawyers that can avoid a lot of problems. First and foremost, the best way to find a lawyer. Oh, yeah, please. The best way to find a lawyer is with a lawyer. And what I mean by that is if you have a lawyer you know, you trust, and you love, whether it's a family member or whatever, a neighbor, somebody that you have a reason to trust, that's a good place to start. Because even if they're a family lawyer or a criminal defense attorney, guess what they did? They went to law school with a bunch of other lawyers. And they probably still know a bunch of those people. And many of them may be technology lawyers, or patent lawyers, or corporate lawyers, or venture capital lawyers. They may have a good resource for you. So you're building off the reputation and the relationship you have with that person. It's like the Kevin Bacon game, right? Multiple layers, you want to start as close as possible. So if you know a lawyer, that's where I would start. Even if it's not the lawyer, because remember, it may not be the right lawyer for you, but start with them because they can help you find that lawyer. And they also understand the legal industry. They can guide you to the one that's a better fit for you, probably. The second option, if you can't find that, or if you're looking for a specialty that maybe is out there, like maybe an FDA compliance lawyer, not everybody knows that person. Trusted advisors. that work with companies like yours, CPAs, bankers, maybe even commercial real estate folks, people that work in your space that provide services to similar types of companies. Startup groups, events like this, talking to people who've done something like what you're doing, particularly if you're in a very special niche industry, and you need lawyers that understand like healthcare, and understand healthcare regulations, HIPAA, and that sort of thing. That's a great option as well. Again, they're not as good as starting with a lawyer, because every step down is a little bit less, but it's so much better than where people go immediately. I started my classes every year, when I have this slide up, and I say, where do you guys go? Before I put the slide up, where do you guys go to get your lawyer? Google. Okay, well, yes, of course we do. I go for everything in Google, yes. But if you find you type in FDA approval lawyer, and boom, you're gonna get some options, right? Now, does that mean the first 3 options are the very top 3 lawyers in that field? No, it just means they have good marketing people, good SEO, okay? They may be the top 3 in that field, but that's not an automatic thing. So let's say you have to go with Google. You have to find the right lawyer. We'll understand first, what kind of keywords to put in there. But then, what's great about law firms is we have great websites, we spend a lot of money on them with bios and stuff. Read their bios. Read their practice areas. Do they really do this area? Or is it just they've used some keywords, they paid for some stuff? Make sure they're the right lawyer by reading their story. There are some online resources where you can kind of do some checking. Avo.com is kind of a Yelp, sort of, for lawyers. We don't really, I guess there are lawyers on Yelp, but nobody really looks at that. Avo is similar to that. They have ratings. The highest rating is a 10.0. Yay, I got one. But that's the highest rating you get. And they can also have, there's some like clients can make referral and make endorsements and so forth. They do that on LinkedIn as well. But Avo is specifically for lawyers. Super lawyers and rising stars, not every lawyer gets that award. And it is somewhat peer reviewed because it has to be selected by lawyers. So that means other lawyers think you're not an idiot. That's a good start. But you don't know how many that is. It just means, a lot of times it's a little bit like, who gets elected cheerleader in high school. It's a little bit of popularity, not necessarily skills. Now it's a real sport. Back when I was going to school, it was about popularity more than anything else. But there's a little bit of that. There's a little bit of a popularity contest with this. Lawyers.com, which was originally Martindale Hub, right? So back in the olden days, when the internet came in paper, I would have to go look up, if I needed a California employment lawyer, I could go to this book and flip through it and see lawyers in California and in cities and counties that did employment law, and that was a listing. Now, in addition to finding a directory of lawyers, they had a ranking system. The highest ranking a lawyer can get in Martindale Hubble is called AV. V has to do with their ethics, which you are on with that. A or B has to do with their experience. So AB is better than BV, okay? They're both good, but if you see a lawyer's AV rated, that's peer review. That means 20 lawyers that were selected by that lawyer, but that means they at least have 20 friends that are lawyers that are willing to go on the hook for them and say, yeah, this person's not an idiot. And then finally, the TexasBar.com. You type in any lawyer's name, and it won't give you a review or a rating, but it will tell you if they've been disbarred, if they have an active law license, or if there have been ethics violations filed against them that are pending or that were found against them. So appreciating that there are some resources that you can double check your homework there. Yeah.
I have a question. I know you mentioned getting the right lawyer, but my question would be, how would you know that they are a great lawyer? Like, what are some key indicators or things that you can look for to know that they are actually doing their job effectively?
That is a great question. I think it leads into this, and it's kind of a chicken egg thing. It's hard to know if they are a great lawyer, because they may have been a great lawyer, they may not be a great lawyer for you. It's got to be a right fit, right? So how do you do that? Well, first and foremost, communicate your expectations. Okay, and what that means is always be talking with your lawyers about what you're looking for, what you really need, making sure they're appreciating of your budget, make sure they're appreciating of your goals, your actual goals, what you really want out of this. I took off another line here. Always be honest with your lawyer. Most of your stuff is protected by attorney-client privilege. Don't hide facts just because they're not favorable. Matter of fact, we really want to know that because we can plan for facts that are not favorable if we know about them. What we don't want to find out is in the middle of a negotiation or in the middle of a trial that there's some information that you withheld from us, okay? Always be honest and tell the truth. Communicate your expectations, communicate with the lawyer. And then I've coined this BDD, budget, deadline, deliverable. I do this in my life. I do it with my contractors. I do it with everybody that I work with, my associates, my partners. Whenever I'm giving an associate assignment, I make sure they know what the budget, the deadline, the deliverable is. What I mean by that is, how much time should you spend on this? If I'm giving my associate a project, and I'm thinking this is a 2-hour project, and they think this is a 2-week-long research project, we're gonna have a problem, right? Because I'm gonna have to write a lot of time, and I'm thinking this is supposed to be delivered tomorrow, and they're thinking it's delivered 2 weeks from now. We're gonna have a hard time. If I told them it's a 2-week project and it's due 2 weeks from now, then that's not a problem. But if I think it's due tomorrow on 2 hours and they think it's 2 weeks, that's a problem. So that is a deadline and a budget problem. The deliverable has to do more with the form and the format, what's expected. So whenever you're dealing with a lawyer, make sure you don't hang up and say, hey, Jim, I need you to form me an LLC. All right, and I'm like, okay, well, that's great, I'll do it. Click. And I send you a bill for $2,500. And you thought this was a $500 deal. I thought when I first heard about it, it was about a $4,000 deal. But I billed you $2,500. I think I did you a great service. That's $1,500 less than I thought it was gonna be. But you didn't know that. You thought it was $500. So you think you got overcharged by $2,000 on this project. If I just told you, it'll be about $4,000. You would have said, never mind, I'm gonna call a different lawyer. Or you would have said, okay. And then I send you a bill for $4,000, you better pay it. Or $2,500, you're ecstatic. Hey, I thought it was $4,000. Yeah, I'm faster than I thought. So the key is understand what the expectations are, right? This goes back to communicating expectations. And so, and this is another thing, I learned a long time ago, I used to give budgets, like when I didn't know the exact amount, like a flat fee, I'd say like, hey Jim, I need you to draft this license agreement. And I'd say, okay, and in my mind I'm thinking, well, this could take 2 hours, it could take 5 hours. If I told you it's gonna take 2 hours or 5 hours, most clients here, 2. They're budgeting 2 hours of my time. In my mind, what do I have? Up to 5. So at my rate, which is $600 an hour, that's a big difference in your bill. Somebody's not happy, okay? And let's say I do it in 3.5. Again, I think I did you a great job. I'm the best lawyer in town. You are so mad at me, you're never gonna call me again. Even though I did it for less than I thought it was gonna be. Budget, deadline, deliverable. Always keep that BDD in mind. All right, I just want to finish with something, the early stage thing. This is my own startup venture. I want to share this before I let John take over. As I mentioned, my hourly rate is a little high for startups. But there is a service that I recently started. It's a subscription-based legal consulting and forms for startup type companies called VinTech. I'm going to pitch that out there. There is a website. If you scan that thing right there, you can get it. I'll give you a second if you want to scan it. I'm going to flip through. Again, this is something that grew out of my students asking me to do this, because they can't afford me and I can't afford to charge nothing. So I created something outside of my law practice that is it connects my law firm to people indirectly. So you can get access to a consult on a subscription base, 1, 2, or 4 a month, already included in the price. And you also have access to like 140 forms that are commonly used by early stage ventures, startup companies, technology-based companies, at no additional cost. It's all built in. And if you do hire my law firm through VinTech, my entire firm discounts rates by 20%, so you're kind of buying down your rate. So it's kind of like, hey, the forms, that's do it yourself. That's going to the pharmacy when you're sick. Teledoc is that consult. Sometimes you got to go to the emergency room. Well, wouldn't you like to have insurance, something that buys down that rate? So this is the best analogy I can give you for the role that VinTech is meant to provide. And specifically in favor of both the Career Center, SMU, and Startup Week. You go on and you just pony up, you get a 10% discount as long as you're a member. Okay. Also, if you're one of those affiliate marketing people, influencer type people, way more cool than me, then you can actually sign up and be a part of our affiliate marketing program, and everybody that signs up, you get 10% of whatever we make up them for as long as they stay members. So this is just comparing what the rates are, just so you have an idea. The main difference between 1, 2, and 3 in the price is the number of included legal consults. They're 30-minute consultations. So at the lowest level, to get you access to everything, they take you $9. Again, there's that scan there. And one last plug, shameless. Oh, by the way, there's some downloadable forms on there, ebooks for companies that just want to fill in some information. You can get a form on how to run an e-commerce company, doing international business. These are free books. You just fill in, you just click on it and download it. I created these, and we'll share them, right? These are all at the same site at the very bottom of the first page. And a shameless plug for my own class, all right? And I do have somebody that can maybe vouch for it. It's not a horrible class, right? It is called Law for the Entrepreneur. I think we saved that name. Yeah, this is okay. And basically, it is not like a boring old law school class. We have projects, we get in groups, and we actually, you're assigned a startup concept unless you have one already, and your group goes through various stages of founding the company, doing an IP thing, all this stuff through this whole process. And if you can click on that YouTube video down there, if you can click that, or go look it up later, that actually is a little video of me explaining a little bit more about the course. But if you haven't enrolled as an MBA student yet, you certainly should. And if you have, then please consider taking the class, because it's actually usually a small class, around 20 people, so it's not a huge class, and it is not me sitting here talking at you the whole time. You guys are doing a lot of group work, and I think it's kind of fun. It's more fun than most law school classes I attended, certainly. So, all right, that is it. And again, I'll stick around for questions after John's, but I'm running a little late, so I want John to be able to come up.
Okay, all right, thank you, Jimmy, all right.